afternoon. I know I've had a few experiences or a few opportunities to talk already, so I'm grateful for Ben giving me the podium again. Going into this, I should acknowledge that my perspective is a lot different from the policymakers, the legislators, and other people that have been up here before who are concerned with creative, engaged ways to deal with the lake in the future. My idea of approaching this is not what the state, what can the state do or what should the state do, but maybe more specifically, what can't the state do? I'm a lot more concerned maybe with policing boundaries and understanding the exact limits of the government's authority, different state bodies' authorities to do anything with the lake. So there are a few times today that I have already mentioned that there is this trust obligation that the state has, that it has to own the bed of Utah Lake. And I know that that sounds very arcane, it sounds weird, and probably begs the question, says who? And so this project talk, I guess, this presentation is to answer the question, who says Utah has to own the bed of Utah Lake? And I identified three sources that I think are significant. The first that I mentioned before is Article 20 of Section 1 of the Utah Constitution. When Utah became a state, it assumed the ownership of different kinds of land. Public endowment lands, in one instance, it owned state lands, and it also assumed the ownership of the beds of water bodies like Utah Lake. The Constitution says that such lands are to be held in trust for the people and can only be disposed of according, essentially, by the same rules that they were assumed in the first place. This is actually a very hot issue, what this trust obligation looks like. As recently as 2019, the issue was litigated before the Utah Supreme Court. It actually involved water courses and rivers, but the state said the best way to understand what the state's trust obligation is to actually look at a United States Supreme Court decision that was handed down 4 years before Utah became a state. It's called Illinois Central, and it's not too important the details necessarily, but in the end, the only thing you should understand is the Supreme Court told the state of Illinois, even if it wanted to, even if it passed a bill enacted by the legislature, it could not get rid of a significant portion of the bed underlying the Great Lakes. It said that owning these water bodies and owning these sovereign lands was an essential attribute of sovereignty, and the state couldn't get rid of that trust obligation in the same way that it can't get rid of its police powers or its obligation to respond to citizenry in other ways. Again, like I had mentioned, Illinois Central does say that the bed of water bodies can get got rid of in very limited circumstances. The state doesn't have the option to punt, to give it to somebody else and let them deal with it. This is in large part so that the public is in perpetual control of what happens to the lake. So that in 40 or 50 years, we as Utah voters will still be able to control by voting through our legislators what happens. This idea of the trust obligation is not new in Utah, it's not new in 2019. Earlier Supreme Court cases in the state of Utah had held that Illinois Central creates a trust obligation in the state of Utah. Although these cases don't necessarily tie this trust obligation to Article 20 of the state constitution, the idea is there, and there's a through line, and courts generally agree, in fact, universally agree, that the state just can't do certain things, one of those things being get rid of Utah Lake. Ben's not here to police my time, so I'm going to take the opportunity to say one more thing, and that is this might be, and this is a little bit more uncertain, but this might be beyond also the ability of the state whatsoever. It might be about more than Article 20 of the Utah Constitution. Like I had mentioned, the United States Supreme Court has previously said that the state can't abdicate its trust in the same way that it can't get rid of its police power or other obligations. When Representative Bremer had mentioned that the state has previously fought for ownership of Utah Lake and fought for a declaration from the Supreme Court that we own the lake, and when the United States Supreme Court made that decision in 1987, it came with the significant statement that ownership of these lands, and again, the court was specifically talking about Utah Lake, so this isn't even 1 degree removed, is an essential aspect of sovereignty. So it's possible that regardless of what the state tries to do, whether by bureaucracy, whether by legislation, or even possibly by fiddling with Article 20 directly, the state can't get rid of Utah Lake because it's not only a matter of Utah state law, but it's a matter of federal common law. And this is actually a position that seemed to be taken in this 2019 Utah Supreme Court case that I'd mentioned before, where Justice Lee referred to Illinois Central and this policing of boundaries as a matter of federal common law. Federal courts had previously stopped transfers as small as 20 acres, so I would imagine that 20,000 acres is probably not too much to ask for. So again, abusing the podium, I should also, or I guess I'm also want to take the opportunity to express this very fundamental view that there's inherent value in policing government, keeping it on a short leash, in constraining and defining beforehand what the government can and cannot do. Because ultimately, if we don't do that, short-sighted legislators, not through any fault of their own, not because they want to be bad or because they're short-sighted necessarily, but there's too much risk at play, and it's better to define beforehand what can happen so that we don't risk losing what really belongs to all of us and our descendants in perpetuity. Utah Lake is too valuable to be controlled in too narrow circumstances, and it certainly can't be just a private matter. And so I know Zoom hasn't been figured out, but it's now the next person's cross to bear.